I'm Ben Meiselas from the MeidasTouch Network. The federal judge presiding over E Jean Carroll's civil rape and defamation trial against Donald Trump, which is set for April 25th, 2023, so only a few weeks away. Well, that federal judge just issued another ruling saying that the jury selection process and ultimately the jurors who are selected, their names and identities will remain anonymous. Judge Kaplan said, "I previously issued an order saying that the jurors' identities would be anonymous, and I meant it." And the recent developments whereby Donald Trump has been threatening the Manhattan District Attorney, Alvin Bragg, and Alvin Bragg's wife, and Trump has been threatening the judge presiding over the criminal case filed by the Manhattan District Attorney's office, Judge Juan Merchan, and threatening Judge Juan Merchan's daughter, and threatening all of the prosecutors who are criminally investigating him. Well, federal judge Lewis Kaplan, who sits in the federal court in New York, who's presiding over the E Jean Carroll case, said that all only further bolsters the prior decision that I made, that jury selection and ultimately the jurors who are selected, their identities, their names will remain anonymous. And so I'll explain to you why this was even before the judge again. But first, let me just explain briefly the jury selection process. So the process whereby the parties select members of the jury, the process is called voir dire. And the way the voir dire process goes is that people who get summoned to show up for jury duty, I'm sure if you've showed up to jury duty, you go into the courtroom where a case is going to be heard. You got jurors who are sitting in the juror box, ultimately where the final jury that's selected will sit. You've got jurors who are seated throughout the courtroom right next to each other in the benches. And then you have the lawyers basically ask questions, and the judge will ask questions of the jurors, the prospective jurors, as part of this process called voir dire, VOIR. D-I-R-E, voir dire, which means to speak the truth, to determine if they can be fair and impartial. Now, the parties can move to disqualify jurors if they can't be fair and impartial, and that's called a for-cause challenge. And then the parties have a certain amount of what are called peremptory challenges, where for any reason at all other than reasons that are racist or discriminatory or otherwise unlawful, if you believe that a juror maybe is not going to be a fair and impartial juror, but you weren't able to disqualify them for cause because they didn't make that clear, you could do what's called a peremptory challenge, and each side has a certain amount of peremptory challenges to disqualify members of the jury. And then as that process concludes, then eventually you have the members of the jury who are seated in the jury box. Now, when the lawyers go in on the first day of trial, they often, that day, they'll get a list of all of the members of prospective jurors who are there. So you have a list of all of the names, and it could be 70 names, 100 names, 50 names, depending on, maybe more, depending on how many prospective jurors they were able to get and who showed up for that specific day of jury duty. But here, the names will not be public. The names will not be on the list. And then the lawyers will never get access to the names of the prospective jurors and the names of the actual jurors, where normally in due course you'd show up and you would get the list of the jurors, and then you'd go through the list. And what I like to do in jury selection is to address the juror by their name, you know, Mr. So-and-so or Mrs. So-and-so or whoever so-and-so. I want to ask you some questions. But here, they'll just have identities, juror number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, et cetera, et cetera, et cetera. Now, why was this even an issue again? And that's one of the questions that the judge said is, look, I asked the parties if you were okay with an anonymous jury. And none of the parties responded to my order. E Jean Carroll's lawyers didn't respond to my order, and the lawyers for Donald Trump didn't respond. So I went and entered the order for an anonymous jury. But here's the thing that happened if you read between the lines of this order that I'll share for you. Both E Jean Carroll's lawyers and Trump's lawyers, for a limited purpose, want to know the names of these jurors in jury selection. Why is that? Because they want to gain information about them, and they probably have experts on staff or jury selection consultants or numerous lawyers who would be doing immediately a search of their social media, trying to determine if there's any issues where there could be a juror who may be trying to get on the jury for whatever reason, who is not showing their bias, even though they're secretly biased. But if you were to do a Google search of them or search their social media, you would see that they're absolutely biased. So here, I think both sides didn't appreciate that the judge anonymous order meant not just anonymous from the public, but even the lawyers wouldn't get the names of these jurors even during jury selection. So what the parties did, the parties then filed a joint request. So E Jean Carroll's lawyers and Trump's lawyers made a joint request to the court to have access to the juror names, even after Judge Lewis Kaplan issued an order requesting these objections to be made if the parties were going to object to the jury being anonymous back in March. And the judge points that out. Here's what Judge Lewis Kaplan ultimately says in his order. He goes, "This court recently found without objection by either party as follows. If jurors' identities in this case were disclosed, there would be a strong likelihood of unwanted media attention to the jurors, influence attempts, and or harassment or worse of jurors by supporters of Mr. Trump. Indeed, Mr. Trump himself has made critical statements on social media regarding the grand jury foreperson in Atlanta, Georgia, and the jury foreperson in the Roger Stone criminal case, and this properly may be viewed in the context of Mr. Trump's many statements regarding individual judges, the judiciary in general, and other public officials, as well as what reports have characterized as violent rhetoric by Mr. Trump, including before his presidency." The court goes on to say, "The likelihood of such difficulties since the court made those findings has only increased. That is so in view of Mr. Trump's public statements characterized by the media as attacks against the New York State judge presiding over the recently filed New York State criminal case against Mr. Trump, and the threats reportedly then made, presumably by Mr. Trump's supporters, against that judge and members of the judge's family. Nevertheless, despite never having objected to the use of a fully anonymous jury, despite ample opportunity to do so, both parties now seek to raise the subject for the first time. They move to modify the court's order to, quote, allow each party's legal team, whatever exactly that means, to, quote, access the names of the prospective jurors, subject, of course, to a court order prohibiting the disclosure of those names to anyone else. The motion is denied."
And now let's take a quick break to talk about our next partner, Lomi. Now, I've never been able to compost before. It was always too complicated, too much work, and frankly, I don't think I even knew exactly if I was doing it right. Then I got a Lomi. Lomi allows me to turn my food scraps into dirt with just the push of a button. Lomi is a countertop electric composter that turns scraps to dirt in under 4 hours. There's no smell when it runs, and it's really quiet. Thanks to Lomi, I have way less garbage each week. My family, we're down from 3 bags per week to just 1. And here's something pretty cool. My wife, she recently started gardening, and we've been able to use the dirt that Lomi produces to help fill the garden. And since I got my Lomi, I throw out way less garbage. That means it's not going to landfills and producing methane. Instead, I turn my waste into nutrient-rich dirt that I can feed to my plants. I feel so great knowing that I'm composting and creating soil instead of waste. And I have basically a limitless supply of dirt for my garden. The other week I had my in-laws over for dinner, and the food cleanup process was such a breeze. Plus, they all think I'm super eco-conscious now. If you want to start making a positive environmental impact or just make cleanup after dinner that much easier, Lomi is perfect for you. Head to lomi.com/Meidas and use the promo code Meidas to get $50 off your Lomi. That's $50 off when you head to lomi.com/Meidas and use promo code Meidas at checkout. Food waste is gross. Let Lomi save you a cold trip out to the garbage can. And now, back to the video.
So basically what the lawyers were requesting be done is what's called an attorney's eyes only confidentiality style order. So what they were saying is the attorneys can get the names of these jurors, but the attorneys then couldn't even tell their clients. So it would be attorney's eyes only. And why did the attorneys both want this? Because they want to make sure through their own research that no one's going to be slipping by and trying to get on this jury that doesn't belong on the jury because they want to be on a high-profile case. The court then explains its reasoning. First, the parties had ample opportunity to seek access for their, quote, legal teams to the names of prospective jurors when the court on March 11th, 2023, directed that any objection to the use of an anonymous jury in this case be filed by March 17, 2023. They filed no objection. The present request is therefore untimely, and that alone is a sufficient basis for its denial, but there are alternative grounds as well. Even if the request were timely, which it is not, it would be unpersuasive because it would ignore the most important reason for a fully anonymous jury in this particular and unique case. The overriding goal is the selection of a fair and impartial jurors who can perform their duties free of unwanted media attention, free of inappropriate influence attempts, and free of any fear of harassment or retaliation, regardless of the outcome of the case. In light of that preeminent goal, I cannot in good conscience grant the request that these parties' legal teams, even if they're attorneys of record only, should have the names of the otherwise anonymous jurors. In so stating, I do not wish to be understood. I have great respect for the bar generally, saying, look, I'm not saying that I don't like lawyers and I don't trust the lawyers. I do not imply that any of those who would be granted access to juror names under the party's proposal would betray that trust reposed in them. But I cannot ignore the fact that the public, of which the jurors ideally will be a broad cross-section, does not have the same confidence. There are empirical studies indicating that the public in general does not have a high regard for the trustworthiness of lawyers, and it is not speculation to conclude, as I do, that at least some members of the jury in this case, if told that their identities would be confidential from everyone except the lawyers, let alone the legal teams, likely would not feel confidence that their identities would remain known only to the lawyers or legal teams. Then the court goes on to say, second, providing prospective jurors' names to counsel would not materially aid and might even hinder the impaneling of a fair and impartial juror. Here, I actually disagree with the court, and I'll explain to you why, but let me read what he says. The court will conduct a thorough voir dire to uncover prospective jurors' potential biases. The parties already have suggested areas of inquiry for the court's voir dire, and will have a further opportunity to suggest additional questions should the court's questioning seem to them inadequate. Yet they have failed to explain the usefulness, if any, of access to prospective jurors' names, despite the careful and searching voir dire examination to which the veneer will be subject. The veneer being the panel of prospective jurors. In federal court, the federal judge leads the voir dire process, whereas oftentimes in state court proceedings, it is the lawyers who pretty much lead the voir dire, and then the judge asks a little bit later some questions. And so here, what the lawyers don't want to say, but the reality of what's going on here, the lawyers want to take these names and run social media searches immediately. That's what they're after. And they don't want to tell the judge, in fear of offending the judge in any way, or in fear of in any way being accused of doing any inappropriate searches on the jurors' identities, which would undercut the very basis for it being an anonymous jury in the first place. The lawyers want the social media data, and they don't want to offend the judge and say, hey, judge, we don't think that your voir dire is going to be effective. But that's really what's going on here. And those social media searches, which can be run very, very, very quickly, can turn very useful information for both sides. And on a case like this, that's why you have both sides saying, let's join as a stipulation together to make sure that we don't have any jurors who maybe hate Trump, and they'll say, I could be fair. And then if you go on their social media, they say, we hate Trump. Or on the other side, maybe there's a secret MAGA juror who tries to get in and hides their identity. That's what they're trying to guard against. Third, counsel on both sides seem to be laboring under the misunderstanding that they would have a list of prospective jurors for this case and could investigate the prospective jurors and or speculate as to their ethnic backgrounds, religions, and various other appropriate and inappropriate subjects, but for the anonymous jury order. But they are mistaken. With unusual exceptions, counsel in jury cases in this district first hear the names of prospective jurors when the deputy clerk calls their names of a prospective juror and invites that person to take a seat for voir dire examination. In other words, the availability of prospective juror names in ordinary cases and the final selection of trial jurors typically occur in a single proceeding that includes voir dire. This is, again, where I think the judge misunderstands a little bit the process. Yes, you will get it that day, but what the lawyers will do is they'll normally try to take the names and then have somebody back at their offices conducting the search and their research. As the judge points out, whether that's appropriate or inappropriate, that's what the lawyers are trying to get out here, but they don't want to say. And then the court goes on to say, finally, for the sake of completeness, the court appreciates the fact that the learned counsel have brought to its attention a few cases in which other courts have allowed lawyer access to juror names in otherwise anonymous cases, and it is aware of other cases in which courts have not done so. I have alluded earlier to the broad discretion reposed in the trial court on subjects such as this. Suffice it to say, this court is confident that the denial of the parties' joint application lies comfortably within the scope of its discretion. That's a nice way of the court saying to both parties, please go away. And really here, the court is very alarmed by Donald Trump's threats. They're very alarmed by Donald Trump's misconduct, the way that Donald Trump would try to cause fear and panic in members of the jury. You know, and honestly, if you want to ask me, well, who does this ruling favor? I think it potentially hurts both parties in a way too. Both parties won't be able to do the voir dire that they may want, you know, and there may be runaway jurors who go on either side, you know, whether it's a juror who hates Trump or a juror who may be, you know, a MAGA person, although I would say in New York, it's probably less likely to be a MAGA person. But the voir dire process is going to have to be a lot more robust and a lot more questioning by the lawyers to try to make sure that they have a jury that's not filled with any runaway jurors. And, you know, you could almost bet that they're going to try to figure out who the names are of the jurors anyway, which is going to be hard, but you can see that that may play out as well. So this case is going to trial, folks. So if you're just keeping track on your calendar, right, you've got E Jean Carroll, April 25th. You've got jury selection in the Dominion case with Fox, unless that somehow settles, April 13th. You got New York Attorney General's civil fraud lawsuit against the Trump Organization, Donald Trump, and his adult children, October 2nd of 2023. For those keeping track at home, and Donald Trump's next court appearance before the criminal judge, Juan Merchan, Donald Trump's criminal case, Judge Juan Merchan, that's set for December of 2023. I'm Ben Meiselas from the MeidasTouch Network. Thanks for watching. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your incredible support. Hit subscribe. Wherever you get your audio podcast, search MeidasTouch Podcast. Subscribe there as well. And check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. We've got great content on our Patreon site, great memberships there. It helps fund this network. One of the main ways we fund it since we don't have outside investors. So check it out, patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas. Hit subscribe on our YouTube channel. Thank you so much, Meidas Mighty. Until next time.
Lock him up! Indictment season is upon us. Celebrate with the new Indictment Season t-shirt and v-neck exclusively at store.MeidasTouch.com.